right. Hello, everyone. Thank you for joining us today. I'm Nicole, a continuing education coordinator for the Collaborative for Accountability and Improvement, and we are thrilled to bring you a panel discussion today on experience with CRP success, a conversation on lessons learned. So please feel free to submit your questions into the chat or Q&A at any time. We will hold all questions until the discussion section of the presentation. I would like to start by introducing today's moderator, Caitlin Harrington. Caitlin is a physician attorney in Seattle, where she splits her time as a practicing internal medical medicine doctor and as an attorney working on communication and resolution program focused projects. Thank you, Caitlin. I will now hand it over to you.
Thank you, Nicole, and thank you everyone for joining us. I am really excited about today's webinar, and I have the privilege of introducing our discussants. So huge thank you to Angela Green, Karen Lorenzen, and Doug Mason for joining us today. Angela Green serves as the Vice President of Safety and Quality for the Johns Hopkins Health System. As part of the Johns Hopkins Medicine Armstrong Institute for Patient Safety and Quality, she is responsible for ensuring a culture of high reliability, advancing clinical excellence across a continuum of care, and setting new operational standards of care delivery. She also holds a faculty appointment at the Johns Hopkins University School of Nursing. Welcome, Angela. Karen Lorenzen is a partner at Hayes, Lorenzen, and Bitterman Lawyers, PLC. She is a member of the American College of Trial Lawyers, the Iowa State Board, and fellow of Iowa Academy of Trial Lawyers, and has an active practice focused on communication and resolution programs. Karen, we're so happy to have you with us today. Thank you. And finally, we have Doug Mason, who is a Vice President of Claims for Copic Insurance Company, and who brings 30 years of experience in the management of professional liability claims. This experience includes the management of complex medical malpractice claims nationwide, from both an underlying as well as an excess exposure perspective. He has spent his entire career in claims and experience in all lines of professional liability. So again, we are so honored to have all three of you join us today to talk about your experiences with candor and communication and resolution programs. I'm going to start with Doug. And Doug, I'm hoping you can give an overview of your work in the field, as well as a few examples that you have seen of candor success stories.
Yeah, definitely. Thank you very much for the introduction. So good morning, afternoon, I guess, depending on where you are in the country. So candor, or communication and optimal resolution, it's an approach which I know some of you are familiar with, some of you may not be. What it does is it approaches and addresses unexpected outcomes in patient care. And the purpose behind candor really is to promote early investigation of what happened, to have transparent discussions with the patient, learn from the incident to prevent similar harm to other patients, and allow for remediation with the patient, which may or may not include compensation when warranted. So I want to start by mentioning that candor or other early resolution programs really should not change the process of early, open, and honest communications when there's an adverse event. Whether candor is entered into or not, we support early discussions between the healthcare providers and their patients. It's something that really should be done in all matters. Right now, we have probably just a small percentage of our cases going into candor. And obviously there's adverse outcomes, and we encourage that early discussion. So my organization, Copic Insurance Company out of Denver, we've been participating in candor for several years now. Our first experience with candor was back in 2017. We're not new to early resolution programs. Copic actually implemented their very own 3Rs program. It stands for Recognize, Respond, and Resolve. This began in 2000. I know other early resolution programs date back to the late 80s. All of those programs gained not only national but worldwide attention, and I think helped spawn the different programs that we're going to be talking about today and that you've probably heard of. So candor, it's present in Iowa, Colorado, Utah, and Minnesota. I know there's other jurisdictions that they're looking at, and it provides benefits not only for the healthcare providers, but also the patients. And I believe that's really why it has gained a lot of support in the different states, not only from the plaintiff's bar, but also from the defense bar. One comment we've heard from trial counsel that it's really vital to have all parties, so both sides of the fence, really at the table when legislation is being discussed. So if there's any issues, all issues really can be addressed then from both sides. So there's no concern. Everybody's going in with eyes wide open. So how does candor begin? Well, it typically starts with an adverse outcome. And there's a discussion between the healthcare provider and the patient about what exactly happened. There may be a discussion at that point about entering into candor and explaining exactly what the candor process is. I'd say a majority of what we're actually seeing is letters that our healthcare providers are receiving or facilities from attorneys on behalf of the patient asking to enter into candor. So they're obviously very familiar with the candor approach and think, you know what, this is probably the best approach that my client can enter into now. So a lot of what we generate into candor comes from that. So once candor is agreed upon, an agreement is signed between the parties to participate, and you're signing the documents so the discussion and the investigation is kept confidential. It's important to make sure, and at this point, it's important to make sure that all parties are participating. I've been involved in a number of candor cases where you may have a number of different providers, you may have a facility. If you're missing key components of the treatment that was rendered that can answer a lot of the questions that perhaps maybe some of the other providers can't answer, it's going to hinder the discussion later. So you want to try and have all of the parties participate. Those are obviously easily identifiable in the records themselves. And oftentimes what the attorney will do is if they reach out to us in the facility, we may see that there's other parties involved. The attorney often sees that there's other parties involved. They may reach out to us to see if we insure them. If we do not, then really that's the attorney's job at that point, and we let them know in order to really have a productive discussion, you're going to have to include all of the parties. Now, it's a voluntary program. I should have started with that. It doesn't necessarily mean because you receive that letter, because other people are participating, other participants are participating, that you have to participate. It's voluntary, but I'm hoping after you hear the benefits of the program that when you get that notice, you will participate, because it's not something that you have to go in and, boy, I'm gonna have to pay compensation at the end. No, oftentimes it's really just to answer questions. We've all been involved with claims where, unfortunately, it's brought about by the fact that the patient or the family couldn't get answers. And they couldn't get answers from their healthcare provider. They may have reached out to them from the facility, and they felt they had no other recourse but to contact an attorney. So candor meeting. So after we get all the paperwork signed, what we're going to do is we're going to get a copy of the medical records from the attorney, or if there's no attorney involved on behalf of the patient, we'll get a signed authorization so we can request them. We're going to do our own investigation. So we're going to do our due diligence. We're going to have it reviewed by an expert. And we're going to determine whether the standard of care was met or not. So subsequently, a candor meeting's held to discuss the findings, answer questions with all of the parties. Settlement discussions are not typically had at the initial meeting. It's usually a subsequent conversation if it's determined that it's even warranted. So as I mentioned, I mean, there are a number of benefits for not only providers, but the patients. What we've heard and what we've seen as far as kind of benefits for the patients is they're now able to meet financial obligations that perhaps they weren't going to be able to meet. They maintain their privacy, their stories not being dragged out in front of a potential jury. They maintain a relationship with either the practice or the healthcare provider. I don't know about you, but if you find a good healthcare provider, it's difficult to find another one. If you lose that trust. And the patient can learn what a practice did to prevent the harm from occurring with another patient. For the provider, obviously you have legal protection. So communication with the patient, it can't come into evidence if there is subsequent litigation. This helps the provider have an open discussion. they can share what exactly happened. Any payments are provider initiated, not in response to a written claim. So as a result, it's not reportable to the National Practitioners Data Bank. So we don't have a written demand. There's unfortunately been some cases early on in Candor where the attorney for the patient may have sent us a letter with a written demand. Unfortunately, that automatically pulls it out of Candor because we can't have a written demand, because then that, like I said, that would be then a reportable event if settlement was reached. What we've seen from an insurance company, so what COPIC has seen is a shorter life cycle. And what that means is we determine a life cycle of a claim from when a claim is first filed until when it closes. And many of you know claims or suits can go on for years. We've seen Candor matters on average, some are obviously longer and some are shorter, on average close with inside of a year. And I mean, that's a tremendous benefit to all parties, not only the healthcare provider, but also to the patient itself. We've seen lower expenses compared to litigated matters. So as far as the expenses that you're paying the attorneys, I apologize for the attorneys on board here, but it's less money that we are paying to those attorneys. And also, you know, it should be stated that in many of the jurisdictions we write business in, plaintiffs are allowed to recover billed medical charges versus paid. We view Candor as a requirement that both parties are open and honest. If there's discussions involving compensation, we ask the plaintiffs to provide us with the pay charges versus what was billed, despite what may be recoverable if the matter turns into a suit. Again, it's about being transparent, being upfront, being honest as far as, you know, what exactly was out there, what was lost. Another aspect at COPIC is that the healthcare team is supported during the process. Oftentimes, what is forgotten during this is the stress that the healthcare providers go through. And I know from discussions that these are very personal, and there are many times when emotional support is needed for our providers. And that's provided through, we have a Care for the Caregiver program. So we're constantly, obviously, talking to our insureds, making sure that they're supported emotionally. Another benefit is to mitigate the risk in the future, as I indicated. I will say, you know, Candor didn't come in on sunshine and rainbows. There's bumps along the way in getting the legislation passed. There was mistrust between the plaintiffs' bar and the defense bar. And that was a real hurdle that we had to overcome. You know, for hospitals that had already embraced a communication and resolution program, it wasn't too difficult to incorporate Candor or another program along those lines. For everyone else, it was asking or expecting people kind of to do things a little differently than they had done. So, you know, many insurance companies, I won't say COPIC was one of them, but many insurance companies had to change their approach, which was, you know, oh, we're just going to deny and defend everything. And, you know, that was a hurdle. I don't want to take up too much time, but I do want to talk about a case study that we had. And this was one where, you know, I actually spoke with the attorneys on both sides because I know the plaintiff's attorney well. And there was a lot of positive that came out of a horrible event. And so our insured was a board certified anesthesiologist providing anesthesia for a hip procedure in a 75-year-old female. The hip procedure was planned to be done under spinal anesthesia. And it was our insured's custom and routine when he had multiple procedures, so he had multiple procedures throughout the day, he was readying his syringes and medications for the next case. I'm sure you all can guess probably what happened. Well, you know, he did this to help with turnover times and efficiency. He said it's actually quite common for anesthesiologists to do this. So when preparing the syringes for the next case, he labels empty syringes and draws up routine medications. So as he's preparing the medications for the procedure, he puts them in two separate sets, puts the sterile medications in a drawer on a cart in the OR, the spinal medications to the side on a sterile towel, the IV medications and propofol in a plastic emesis basin. Once he's in the OR, he uses the medications he's previously prepared. So for this procedure, enters the OR, talking with the after talking with the patient, surgical team was getting the patient positioned with her back towards him so he could place the spinal. He says he went into the drawer where he put the medications he previously prepared, grabbed a syringe, which he thought was the right medication, even thinks he looked at the label. And unfortunately, what happened is because both medications had a white label, while he thought he had the right medication, he accidentally injected a neurotoxin into the patient. Miraculously, she survived. The error was disclosed immediately to the patient and family. The case was worked through candor with representatives for the hospital and the insured and claims adjusters. And when I say all parties are beneficial to have at a candor discussion, the operating surgeon was there as well to answer any questions. Now, the operating surgeon wasn't a player and wasn't going to be offering compensation, but there may have been questions for that individual, so it was good to have them there. What I was told by the attorneys, and this came from both sides, it was incredible, it was healing, it was restorative, productive, and an informative session, exactly what candor should be. Our attorney participated, indicated that it was the best candor experience they ever had. So immediately following the insured so you might be wondering, okay, so what happened? So the insured proactively made changes in his practice, was now able to share that with the family at the time of the meeting. So they were made aware of the fact that, listen, this is what happened. These are the changes that we have made. So we're not going to have those errors in the future. Hospital also made system-wide changes and explained their new procedures. Family asked questions, kind of shared their perspectives and emotions. What I heard is there was really not a dry eye in the house at the time when everybody was kind of just sharing the information, what they had gone through. And each family member, this kind of hit me, each family member offered forgiveness to the physician and a sincere wish that he now put this behind him and prosper. I mean, that's like I said, amazing healing kind of on both sides. There was compensation offered and it was resolved, but really that's kind of an after effect. What was really beneficial was obviously the meeting, the changes that were made, and what was able to be informed to the patient. Because in the past, none of this would have happened. This would have resulted in a lawsuit, maybe 3-4 years down the road. Sure, there probably would have been compensation paid, but it wouldn't have had the effect that it did going through candor. And I know I've taken up a lot of time, so I don't want to go into another case. If we have time later, I've got another case I can share.
Doug, thank you. That was so valuable. I really appreciate both the global overview and then the really personal case too.
Sure.
So thank you. Karen, I'm going to turn to you now, and I'm really excited to hear about your experience in this field.
Thank you, Caitlin. I appreciate that. So I got started in candor. It's probably back in 2016, 2017. Iowa did kind of a pilot program at a smaller regional hospital in Burlington, Iowa. And myself and a defense attorney who had a lot of experience in medical malpractice defense, we were sort of the two primary attorneys involved in this pilot program. And they identified, the hospital initially identified cases where they felt candor would be a good way to resolve both the questions, medical issues, and potential compensation of the patient. And so we went through this process, and it's interesting, Doug, because the other attorney's name is Connie Alt, and she and I did a presentation at the Iowa Medical Society shortly, maybe 6 months into that program, which, you know, Connie knew everyone. I felt a little more like the enemy in that arena. But one of the only insurance representatives there was from Copic. So interestingly enough, we had a lot of doctors, we had all the folks involved in the Iowa Medical Society, and Copic was front and center. And that was really before Copic was doing much by way of insurance in Iowa. So I thought that was a really interesting and telling, it just gave us a good idea of who you guys are. I have since had a couple of one not 2 weeks ago, resolution with a Copic client. So we've had good experience with you guys. But that's kind of how I got started, Caitlin, was this pilot program. And then we were involved in putting Iowa's candor statute together, which has since been amended once. So I think the original was like in 15, 16, and then we amended it in 17, 18. Just as we went through this pilot program, we were able to sort of fine tune some things so that they worked better. I agree with Doug. Typically, especially in the beginning, it was strange because I was getting candor referrals from the hospital. So I'd get a call from a client and they're like, so-and-so at the hospital gave me your number and said I should call you, which, you feel a little like, oh, that maybe is strange, but that's sort of how it got started. Then I started to be able to identify as the process grew in Iowa and different hospitals got involved. And we still have some that I think are really reluctant to do it, but we have others that have bought into the process. Great River, where the pilot program was done, the University of Iowa, they're fully on board with this process, what it brings to the table. I started to be able to either email or call deputy in-house counsel, who I know very well and work with very well, and say, I really think you should take a look at this. I think this is a potential candor. And then they go about their process and they come back to me. And I'm very careful about any written communication on candors, because I think one of the big benefits to the facility, to the physicians, is this: you don't have to report any financial, as long as there's not a written demand, as long as certain things don't happen. That's important to the physicians. And in 30 years of practice, I know what a big deal that is for doctors to have to report to the national database. So that's kind of how it got started for me. I would say now, I did look because we talked about it. Statistically speaking, I'd say it's maybe 15% of my practice. Sometimes it'll kick up and it'll get to 20%, but we have a very active trial practice. In any given time, I think I was trying to make a quick count, and I want to say I've probably done personally, not the office, maybe 40 or 45 candors since I started. I've talked with other plaintiffs' attorneys in Iowa who were skeptical about it, and assisted them in trying candors in different settings. I think it's more accepted. I think the plaintiff's bar can be distrustful of it. As we've spoke about previously, Florence LaCroix, who's a wonderful advocate for the program, and speaks on it. She did a grand rounds at the University of Iowa. I assisted her by giving testimony and answering questions from the Georgia House on their Health and Human Services when they were considering candor. Unfortunately, it did not pass, but I spoke to them. I spoke to a group of plaintiffs' attorneys and tried to explain, I think the plaintiff side, there's always concern about time, right? Because it's really like 2 years, most places. You have 2 years to initiate a suit. And they're very concerned because, for obvious reasons, the defense and practitioners don't want to stay the statute of limitations to allow this process. And the plaintiff's attorneys get very nervous that they're not going to have enough time, or that it's going to be a way to run out the clock. And I think what I've learned over time is that it's sort of my process now. It's like, it's almost like a parallel investigation, right? Like, I go about these candor cases and I'm not spending the money I normally do on, 5 or 6 experts to cover every aspect of the case. I have sort of the expert who can give the overview, or maybe it's 2, so that we know and we can really talk with the family about, is this a complication? Is it truly a failure in the standard of care? Like, is it somewhere in between? Because that's really important information for the patient to have as we head into the process. And then a lot of what I do is just explaining to them that the information that's available in candor is not available in litigation. And in that way, I agree with Doug wholeheartedly that it's a very cathartic process. The patients truly get to speak in a one-on-one situation to the impact that this unexpected complication has had on them, on their family. And I don't know that patients routinely feel like that comes across. And then they get to have answers. And I'm always, I try very hard to point out to them that you don't get that answer when you file suit. They're going to claim peer review privilege. They're going to claim, and so part of, I think, the hard part of litigation for most patients is you don't necessarily get to know or see what the change is. It really becomes about who's right, who's wrong, and is there going to be compensation? And that's fine for some folks. I mean, that's maybe better situated for some claimants, but for a lot, I really feel like it's the process, it's the discussion, it's knowing that things have been done so that this won't happen again. And it also provides an avenue for claims that could not otherwise, because of cost benefit reasons, right? Like the expense of filing a medical malpractice, the time involved. Lawyers with busy practices can't take on $25,000 claims. You can't. Or you can take on one or two a year in a pro bono fashion. But when you do them as candors, you do provide this sort of avenue of recovery. So like Doug, I kind of dug back through some old cases, old candors, and there's one, I think, it's funny, Doug, it's kind of similar to yours. So we had young family, mom had a very complicated labor and delivery. And so baby was being observed, and they needed to do a contrast CT. And for infants, contrast is typically oral. And so, mom's with baby is less than a month old. And they're waiting around. The contrast comes up to the nursing station from the radiology department. It's mixed with tap water. And it's supposed to be given orally to the infant, and it's put into her IV. Which is a very bad thing. Water in hospitals are routinely filled with any number of bacteria. And so there was a lot of unrest, right? Like what is the exposure for my infant child? And so the hospital was good. They called in infectious disease. They make these decisions that we have to cover her with some pretty heavy duty drugs. So she was placed on vancomycin, gentamicin, and an antifungal to make sure, because of the use of the tap water and it being injected into her system, that she was going to be okay. So she recovers from that. And then at day of life 23, they did routine hearing tests that they do on infants, and she showed unilateral hearing loss. And so they kind of scratched their heads, and 2 to 3 days later, they repeated the test, and now she was showing bilateral hearing loss. And part of what we figured out is that it was the ototoxicity of the vancomycin and the gentamicin. It can happen. And she had true hearing loss. So we got involved in the process. I hired a really, interestingly enough, a very good pediatric otolaryngologist from Johns Hopkins who helped me kind of work my way through, which agent, was this truly ototoxic hearing loss? The little girl recovered hearing on one side, but had significant loss on the other. And the biggest concern was, so young, when you lose hearing, are you going to make your milestones? Speech becomes more difficult. So all of these things the parents were truly just overwhelmed by. And we went into the candor process and not a dry eye. I mean, amazing job by the university. They had pictures, and what we discovered was they absolutely changed the way that contrast was mixed for infants. So it was all done in the radiology department instead of setting up to the floor and having the nurses do it. The receptacle that the tube that the contrast was contained in was made so that the tip could not fit into the port on an IV. So even if you had that moment, and this was a very experienced nurse who was very upset with her mistake because she knew, I mean, it says oral contrast on it, and she just had that moment, hooked it up to the IV and pressed it in. And so they made the systemic change to ensure that that could never happen again. There was financial compensation, but I think the thing that gave the family the most relief was what they offered was ongoing testing of her hearing aids as she grew. They have a wonderful otolaryngology department at the university, and there was some discussion, would this kid need a cochlear implant at some point? And so all of that worry was taken off the plate of the parents. And they were so relieved by those discussions, and the university was so relieved to kind of create an answer, and basically they bettered their systems as a result. It is one of my favorite candors that I've ever participated in, because everyone left the room in a better place than when they entered it. I don't know where we are on time, Caitlin, but I don't want to extend too far past my time allotment.
That was fantastic. Thank you, Karen. That's such a powerful story as well, and really highlighting, I think, the power of open communication and then knowledge. So knowledge of how things are changing, how important that is.
Yeah,
Oh,
I would
sorry.
say my interaction with healthcare providers that actually buy into the system, they get it. They may be reluctant to on the front end, and on the back end, I would say 90% of them see the benefit.
Absolutely. Absolutely. No one goes into healthcare to hurt people. So it makes a lot of sense. You feel terrible. Really powerful. Thank you. I'm going to turn to Angela now. And Angela, I'm really excited to hear about your experience in this field.
Thank you. So, my story begins with a couple of decades as a nurse, taking care of infants and children in critical care, and spending the last couple of decades as a nurse leader focused on patient safety and quality. And my why for communication and resolution programs really starts with a time in my life when I was a quality and safety leader at a local hospital. And we had a series of events and outcomes that were highlighted in a local newspaper. And the system president and I met with the patients and families whose stories were highlighted in the newspaper and committed to transparency and accountability to those patients and families. A very powerful and life-changing experience in lots of ways. But really, out of that experience and our learning as a hospital, we committed to a longer-term goal of implementing a communication and resolution program. So we started that work at a single hospital in December of 2020. I was the local leader, and that as part of that work, we really learned that we wanted to implement across the Johns Hopkins Health System. So while in a local leadership role, I began to lead the implementation in some of our other sites. And when I transitioned to my current role 14 months ago, I have continued to be the system leader for communication and resolution programs. Currently, we have this rolled out at 6 hospitals across our ambulatory enterprise, our ambulatory surgery center series, and our home care program as well. We see this as really part of our event management processes, the routine work that patient safety and quality and risk management leaders do when we learn of adverse events. Not only do we commit to investigating and learning, we commit to an ongoing journey with the patient and family And we found it on the principles of transparency, support, learning, and accountability. So how it looks if you're at a local hospital and there is an unexpected adverse outcome, the clinical teams, even before the implementation of communication and resolution programs, our clinical teams have been amazing at that initial disclosure. Here is what we know. The thing that has changed is, in addition to that, we commit to learning and commit to staying in conversation with the patient and family as we learn. And then what we call a resolution conversation, where we share what we learn and then hand off to our claims and insurer team if we have learned that the standard of care was not met and there is significant harm to the patient and family. So one of the things that as we I prepared for this session was really, what are the key lessons learned? And I think one of the most important was that we committed to this as standard work, that when we have adverse outcomes where there's at least moderate temporary harm, that we embark on this journey with the patient and family, and that we commit to sharing what we learn. We integrate it into the process rather than this being on top of our routine event management process. One of the things that was interesting, and I think when we talk to other hospitals about implementing, is to avoid the trap of believing you already do this. So when hospitals first think about it, they think about that tip of the iceberg where there's severe harm and just a known breach in the standard of care. And sometimes there will be proactive settlements minus CRP. So the trap of believing you already do it, as people are learning about CRP, they start to believe, well, we do a good job with disclosure, and there are cases that we have proactively settled. And really helping people see from the beginning how different this is, and that this is not waiting till someone sues. It's not waiting until you think we have a high risk of suit. It's starting this journey with the adverse outcome before we know whether the standard of care was met or not. I think the other big lesson learned from the hospital perspective is very similar to that prior lesson. Those events where the standard of care is not met and there's serious harm, that is the tip of the iceberg for us. So if I've read that for some institutions it is less than 2%, I think our experience is it is definitely lower than that. But what we think we're preparing for is those cases where the standard of care is not met and there's serious harm, and that is a fraction of our cases, when in fact we're preparing for and resourcing that much broader pool of unanticipated outcomes. So really helping the team see that the denominator is much bigger than those cases that we call insurer cases, and really making sure that we resource so that we can have the type of relationship and ongoing dialogue with patients and families that we believe is key to this process. Then the final lesson learned for me, I put into a bucket that I call suffering people. And the patients and their families are suffering because of what happened to them, and they suffer because they don't know. Sometimes they suffer because they think no one cares that this happened to them. And when we're working with teams and prepping them for, in particular, that conversation that we call the resolution conversation, where we're sharing what we learned and what we've done to improve, we prepare that it may not be all hunky-dory. You're not going to be transparent, share what we learned, and suddenly everybody's going to be smiling and happy. That we need to hold space for whatever emotions are there, and to recognize that families will still be sad, they may still be angry, but there is a piece of their suffering that we can help with, and that is the suffering of not knowing, and the suffering of believing that the hospital doesn't care, and that they may be angry at the end, they may be sad at the end, there may be tears, there may be smiles, but that where we can offer an alleviation of their suffering is in those two places. Doug mentioned the suffering of the teams that are involved in these cases, and I think we anticipated that. Many of us who were implementing these programs were care providers ourselves at one point in our careers, And adverse events is a lot of our daily work, and engaging with teams and learning from them is part of our daily work. So we proactively deploy our resilience and stressful events team, so caring for the caregiver type team, to those teams that have been involved in events. I think the big lesson learned and surprise for us was the emotional work for the CRP teams. While we interact with adverse events as part of our daily work prior to communication and resolution programs, we were really not in relationship with the patients and families that the events occurred to, and certainly not over a period sometimes of a couple of months as we continue to engage with patients and families. So I think a big lesson for us is, how do you support the communication and resolution program teams who are really engaging with patients and families over longer periods of time and over larger numbers of events. And I'll end with a story that we all enjoy, because I know we want to leave some time for questions. But one of our teams kicked off their communication and resolution program and almost immediately had a really serious event with some permanent harm to a patient. And they were engaged with this patient and her family over a period of months as we learned and worked to provide financial resolution to make sure that her care needs were met. And they described really a relationship that progressed from someone who was very angry and very sad to someone who was pretty businesslike in their interactions with them. But over a period of time, when this ladies came to campus, she would tell one of the CRP team members, I'm going to be on campus if you want to come and say hello. And they really valued that because they could see her recovery, both physically and emotionally, and really valued that opportunity to just say hello to this patient that they had worked with in our CRP program. And a story that all of us enjoy is that early in that time where she would receive a call, you want to come say hi, I'm on campus. It was a silly sweater day, and there hadn't been a lot of laughter and smiles with this patient. And this team member thought, oh my gosh, I don't have anything to change into. I guess I'm just going to have to go in this sweater. And she said that when she walked up, the patient just burst out laughing, and that they hugged one another, and they just really were just laughing about the sweater that this person had on. And just, that story of being in relationship, it doesn't always end like that, but just the opportunity to engage with this lady over the course of her recovery and just even have that moment of laughter with her was so meaningful to this team. And with that, Caitlin, I'll hand it to you to make sure our audience has an opportunity to ask questions.
Thank you, Angela. There were so many pearls there, and I especially love the idea that the communication is not just the initial communication, but it's this ongoing relationship, this ongoing learning and support. Really valuable. So I have a few questions. I also want to highlight one question that came in from the audience as well. So I'll start with that and then turn to a couple of other questions for our discussants. And please, folks, feel free to send more questions in on the chat as well. I'll be looking at that. So Doug, I think this is probably a question for you, although Angela, Karen, value your insight on this as well. And the question was, how does a medical provider find out which states or hospitals or malpractice carriers participate with the program? And I think that's probably candor is what I'm thinking that question has to do with. I would also say that for CRP programs, like Angela was saying, often those are institutions. So the medical provider would know their institution is doing a CRP.
Right. Yeah, I would agree with you there, Caitlin, with regards to the CRP programs. Those are usually driven by the institutions, and the provider would typically know that with the institution he or she is with. But with regards to candor, so those, as I indicated, is with regards to the states that have candor legislation. Currently, it's Iowa, it's Colorado, it's Utah, it's Minnesota. I thought I saw in the chat that it looks very close for Georgia in the future as well. So I know it's so currently it's in those states. But as I indicated, I think even absent the candor process, we definitely recommend having those early and open and honest discussions with the understanding that, you know, what is being said may not be protected during, you know, legislation, but we think it's really best for, you know, for patient care to have those discussions when when there's an adverse outcome.
Absolutely, really valuable. There is another question here, and this one I think really, Angela, in some ways really fits with what you were saying about the challenges for the Candor team and how they're supported. And the question is, I do wonder if there are ways to help managers and leaders after harm. I agree there's a gap here and have seen amazing leaders leave. And so, Angela, I appreciate your thoughts on that.
You know, we have been fortunate that we have a long-standing peer support program. RISE is the acronym, Resilience in Stressful Events, that was really intended to support those at the point of care in really stressful events. It began as after adverse events in care, but it has broadened to a sudden tragic loss of a team member. So I think building those peer support programs, whether it is a formal program such as ours, or identifying individuals on a department level that can participate in providing just a kind listening ear to someone. The other thing we're learning is that in both for organizations with peer programs and without, just the opportunity to debrief events with a skilled facilitator is a good way to help teams process what has happened and begin to work through some of the emotional aspects. And then, you know, we were not proactive about implementing peer support for our CRP teams, but we are finding that the leaders of the CRP teams are forming an informal network where they, you know, offer support to one another and dialogue as we work through the events. But we're really in conversation with our formal program on how we can deploy team members to support that other set of individuals who are involved in the emotion of the care.
So valuable. I love the idea of debriefing too, just like you would do in a healthcare setting after a code or something else that's quite traumatic. It makes a lot of sense. Karen, I have a question for you, and that is that what I've heard many times is that one of the challenges to overcome is sometimes mistrust between the plaintiff's bar and the defense bar. And I would really love your perspectives on that and sort of your thoughts on how we can really start to overcome those challenges.
You know that, Caitlin, it is a challenge. It's even a challenge in Iowa where there is legislation. There are just, and I think part of it is, unfortunately, it's not process driven, right? The process, but the process requires buy-in. So, for example, when you do a candor, and they don't always, as Angela and Doug have mentioned, there's not always compensation. And those types of candors, when I do them, I treat them as pro bono work. And so we go in, and it's sort of part of the buying into the process. So sometimes you still have a part of the plaintiff's bar. And I had this happen recently. You know, it's probably, in my estimation, it's a clear failure of the standard of care. It's one of those that it's, you know, it's very obvious. Woman who was having a surgery, someone who's not identified at this point rests the cautery on her abdomen and basically burns a hole in her abdomen, ends up in like a 4-inch scar. She's got some numbness. It's near, so it's not a big claim, but it's a clear candor. The provider wants to candor it, and an attorney friend of hers, who I know, who's a plaintiff's lawyer and well respected, basically said to her, "It's not worth my time." So you have to get that. And then on the back end, sometimes what happens, and I've seen this, the hospitals will engage outside counsel and sometimes it's the manner in which the outside counsel goes about it, which is not necessarily consistent with the way someone like Angela or in-house counsel goes about it. And then you end up in a situation where they're just simply treating it as like a pre-suit mediation, and so you really, I think the mistrust is based on not either understanding or buying into the process itself. And that's where I think, educating people, doing these webinars, getting them to understand that the true benefit, yes, most of my candors have resulted in some settlement to my clients, but the most productive part of that process is what those patients learn, the ability to keep their relationship with their healthcare providers, the ability to see their healthcare providers' humanness. I mean, just that they feel bad because doctors, I've spoken, I've lectured at the medical school, and you get the barrage of questions, and they're just conditioned to don't say you're sorry, do not admit a mistake, don't, and that's stressful. I have plenty of doctor friends who talk about the level of stress when you want to be compassionate, but it's been ingrained in you, don't do that, And so this process, I think, heals both sides and allows a physician-patient relationship to continue forward. Whereas that's never the case after litigation, right? There's not good feelings, no matter who wins and loses. And so I think part of it, Caitlin, is up to the folks that do this to educate both sides that every candor doesn't have to be some financial benefit to you, either as a defense lawyer, less hours, less billables, plaintiff's lawyer, smaller recoveries. Some of us take lesser percentages to help facilitate the process. You have to get them away from what traditionally causes them to take a case and understand we're sort of all buying in to make the process better. And I don't know that there's a quick fix for that, but I think these kinds of webinars are helpful.
Absolutely. Culture change is slow, but important.
And if I could piggyback on what Karen said. So I know she mentioned as far as a lot of the candor matters where a greater percentage ends up in compensation being paid. And I'll say that's actually quite the opposite of what we're seeing, but extremely beneficial because we're still able to provide that information. And then as far as the mistrust with the attorneys, I agree. I mean, it's there. And I think if you have that involvement at the beginning when the legislation is being discussed, is being before it's even passed, and if you can have that involvement from both sides, then like I said, they're going in eyes wide open. They know exactly what the legislation's about. And I agree with Karen wholeheartedly. I think we need to continue to have webinars like this to educate individuals out there so they can become familiar with the process of candor. And lastly, it's so important to have, I was thrilled to hear Karen said our involvement in Iowa, COPIC's involvement, but it's important to have the involvement of the insurance carrier in the state. And sometimes there's multiple insurance carriers in that state, but it's really important to have, that buy-in as well.
Absolutely vital. Yes, absolutely. Really, really important. One more question. It's coming from the chat, and this is thoughts on communication with the state medical board on how it will view candor cases. And I'm presuming this maybe comes back to the practitioner's database, sort of how things are reported, not reported, things like that.
Yeah, and I know through our work with candor in those states that we've been heavily involved in the legislation that, we work with the medical board to make sure, obviously, that we have that protection as far as there's not reporting that's necessary. Now, it doesn't necessarily mean that a patient can't later make a complaint through the medical board. They can. But if there's compensation paid, often in many jurisdictions, you're going to have to not only report to the data bank, but you'll have to report to that medical board as well. With candor, you would not.
Fascinating. And Angela, I see your message in the chat, which is as a health system that you engage with insurers proactively. I would love to hear more about that.
When we started moving beyond a single hospital, we have a primary insurer for our hospitals. We engage with that insurer very proactively to discuss the process, engage their support. And then we have a a number of physicians across the system who are not employed by us or the university and looked at the most frequent insurers for those physicians and had just proactive conversations. This was, of course, after we had introduced what we were working on at the hospital level and the clinic and ambulatory surgery site level, so that the providers were aware. They were asking us, right, if you're going to do this, will you also please just have conversations with the insurers in advance of coming forward with a discussion about a particular case.
That makes so much sense. I could continue this discussion all day, but I do see that we have approached the end of our webinar. So I want to just take the last moment to say a huge thank you to all of you. Doug, Angela, Karen, thank you so much for joining us. Thank you for sharing your wisdom, both as a systems level and also deeply personal stories. So powerful. And thank you to everyone who joined us in the audience too. We really appreciate it. All right, Nicole, I'll turn over to you to the end.
Thanks so much, Caitlin. Thank you for moderating such a wonderful session today. And thank you, Karen, Angela, and Doug for sharing your experiences with the community. It's just really so valuable. For everyone in the audience, thank you so much. The session is recorded. It will be available on our YouTube channel in a week or so if you want to share it with your colleagues. We would appreciate that. And just want to let you know that next week we're actually having another webinar as well. We're lucky to have the President's Council of Advisors on Science and Technology working group members, Sue Sheridan and Julie Moran, talking about the report implications for CRP leaders. So make sure to register for that as well. And with that, we thank you for joining us today, and we'll see you all later. Thank you so much. Have a wonderful day, everyone.
Thanks.
Thank
Cool.
you. Bye-bye.
Bye, everyone.